Hey folks, good morning. I'm attorney Roger P. Foley, driving to the office, and today I'm going to talk about an issue that you don't hear a lot of attorneys talk about, and that is when the client and the attorney don't agree, or the client's family and the attorney don't agree. So let me tell you about some fun cases from back in the day. I had a case where an attorney hired me. It was a newer attorney, and the attorney and her father, who was also an attorney, hired me to represent them in a DUI case. And the case seemed a little bit odd. The client said that at some point, not necessarily at the beginning, but at some point said that they were sleepwalking and sleep driving. And you know, that's sort of an unusual circumstance. So they indicated a drug that they had been prescribed, and that drug was called Ambien. And a lot of people know what the drug Ambien is. And there are some studies to suggest, and a lot of people have said that they've slept walk, and didn't remember doing and acting, and they're outside cutting their grass, or they're watching TV and they don't have a recollection of it. So I said, okay, well, I will research the issue. And at the time, I researched the state of Florida. I researched the entire country. And the father, the other attorney, he had given me some documents regarding cases that he had heard about in the news. So I tried to follow up on it. I really do listen to what my clients are saying to a point. When I say to a point, I listen to my client, but like when their family members are directing, sometimes that can be too much for me, right? If you're an attorney and you want to represent your son or your daughter, by all means, represent your son or your daughter. Don't stand over my shoulder and critique every single thing. So that's where it sort of started. I did all the research. I found that there had never been a successful case of an Ambien defense at that point in time. There may have been since, but up until that point, there wasn't. Now, the problem with trying to, I'm all for thinking outside the box. The problem with that case is that the client blew like a 1.2 or a 1.3, 0.13, which is, like 0.08 is the legal limit. You have to be under that, so obviously way over, not quite double, but definitely over. So even if they were sleepwalking, it's not like I could say, well, they didn't ingest the alcohol, right? Because what is the basis of a DUI? Your normal faculties, your ability to walk, talk, see, hear, and act in emergencies. Well, this person was driving a car. So again, me personally was like trying to sell someone that I was sleepwalking when I committed a crime and I wasn't aware of it. I think that's a hard sell. Can you imagine, like, ladies and gentlemen, they didn't rob the bank. They were actually sleepwalking and dreaming that they had firearms on them, right? I know different facts, but like my client was driving down the street, weaving into traffic. It was 15 miles from their house, but they weren't aware of, well, you had to be somewhat aware, right? Because you're driving a car. But anyway, I still look to think outside the box. Well, when I found one case of a senator while in case filing, I forget where it was, like Washington or something, where a case had been declined, meaning a formal information was not filed. That was the only thing I could file, and the guy was he was a senator, so it's not like the average Joe, was having a case. And obviously, we all know, like, politicians and people in places of power sometimes get preferential treatment. So I explained to the father that I thought that the case wouldn't work the way they wanted me to do it, and I said I think it would be like malpractice. Like I don't think I could go to trial with that issue. And they said, what about emotion? I go, it's not going to work. I mean, it's not even a 1%er because there was a huge amount of alcohol in the system. Anyway, they got very upset, and the father and daughter, gave me lip and said, hey, we don't think you're very good, or, whatever. And they went and hired someone else. And I followed the case just because of pure interest, because, hey, if someone does something that I can't do, then I got to rethink myself, so I can't do it. So they hired some attorney who talked about, who advertised like females are different from males, and then he still made this Ambien argument, and like it was instantly it was shut down in 10 seconds by the judge. So they weren't happy. They didn't write they didn't send a nice review. Then I had another gentleman who is stopped for speeding and weaving and going over a curb, and that person is taken out of the car. They do exercises. They don't do very well on the exercises, and they are charged with DUI. Again, it's another DUI case. Now, search incident to arrest, they found drugs like hydrocodone, oxycodone, some weed, etc., right? So I think there's like 3 or 4 different drugs. So I get hired on the case. Well, part of the facts that I just left out is that the officer, when he does the DUI arrest and he does a search incident arrest, he realizes that the person works at a hospital, right? So the person is a medical professional. The police officer finds drugs that are normally prescribed, and I don't know if they're in containers or whatever it is, but they put 2 and 2 together. It's actually pretty good police work. And when they realize that the person works at a hospital, they go to the hospital and follow up. Now, this medical professional, it turns out, well, the allegations are, right, is that they are stealing patients' medication. Think about that, right? One for you, one for me, 2 for you, 2, 3, 4 for me. And the people who are, in car accidents or sick or cancer patients or whatever that are getting pain medication are not receiving their pain medication because this person allegedly has acquired their medications. And there's an internal market, right? Because medical professionals, they have access to the drugs, and they found that this medical professional was basically taking some drugs from clients. They found at least 1 or 2 instances of it. So what happens? The person is charged with the drugs, and it's kind of crazy. They ended up not being charged with the stealing of drugs, which I think they easily could have. But I accepted the case, and I was working on the case, and the parent, another lawyer, forget what they did, but something totally different, right at the very onset said, hey, da-da-da, and I said, listen, if you want to represent your son, like, I have no problem with that. I mean, but if I didn't want to work the case with the family member that was an attorney, right? You could just imagine that. And I have worked with several other attorneys on cases where we both come in as co-counsel. It happens a lot, actually. So, but this family member was even difficult at the first interview. So I said, hey, listen, it's a DUI and a drug case. So if you want to do it, But I'm just going to ask you, and I'm going to put this out at the first meeting. If you want to be heavily involved, I'm probably not the right attorney. Well, what happens is this person, their family member, keeps like riding me. I want you to do this. I want you to do that. Listen, I don't work for you. I work for my client, and I do what's best for the client. I may give the options of go left, go right, and they choose and I go that direction, but respectfully, you're not going to tell me how I'm going to run my practice or how I'm going to run my case. You're not my client. So again, I give clients options, but I will heavily advise against certain things. So I ended up working, I severed the cases, I severed the drug charges from the DUI, so they're in separate courtrooms. There's a formal review hearing. I went to that, I won that. I got the motion granted to sever them. And then I put them in drug court on some drug charges, and I was going to do some motions and try the DUI. Now, I had to take depositions, right? So I'm taking depositions of the officers. The family member, the friend, whatever, is killing me, like sending me emails. You say this, I expect to see it's just funny. I expect to see these questions in your depots. Like, you're like, who are you? Right? Like, you're not going to tell me like what questions to ask. Like, you may be an attorney, but you don't have knowledge in the specific area. And I'm trying to kill with kindness, but it got to the point where I was like, hey, to the client, I'm not going to deal with this person anymore. I'm not taking their phone calls. I'm not, if they want to be on the phone with you, but so I do everything. There was a cool issue in the depot, and I dealt with the medical, like when doctors have, there's a medical profession, the medical board, right? So I dealt with the medical board. Well, I succeeded with that as well, right? So they basically hired me for the cases. So we ended up with 2 cases, and then the medical board. So convinced the medical board to give the person treatment, and was trying to work that treatment into the same treatment that was through drug court. Succeeded in those endeavors. Now, I explained to the client there's a motion, and again, they got upset that I wouldn't speak to the family member, friend, whatever it was, and they ended up firing me on the DUI case. That's all that was left, right? The drug case was, as long as the person completed it, they were doing it. The person was going to keep their medical license, and it was, lastly, you either win or lose a DUI. You're either looking at technical issues or trial issues. So I came up with some issues, and issues that I used to win the formal review hearing, the DMV hearing, which is separate and apart from the case. So and they hired someone that I happen to know, and I had already done the depots. The case was ready to go, but they fired me. That attorney ultimately went to trial on the DUI and won. And very, very nice person. That attorney called me and said, hey, after I polled the jury, afterwards, right, I got to talk to some of the jury members. It was the issue that you found, Foley, like in your depot, that I brought up, but I didn't even think it was that big of a deal. But that's what the jury hung their hat on, and that's how the client got to not guilty. But I got fired, and a negative review and what have you. So, are there attorneys that don't make the effort, that don't work hard? Of course, every profession. But sometimes clients just get mad because you explain to them the risks, and maybe someone else doesn't tell them the risks, or doesn't explain it thoroughly, or I don't know, regurgitates what they want to hear. I see a lot of times where that doesn't work out too good, and people end up being sentenced or whatever because they're not thinking rationally. They're too close to it, and that can happen as an attorney. You know, both of those situations that I just explained, you know, had family, friends that were attorneys and were involved. I had a case recently, which we ultimately won. We filed a stand your ground motion, and once we did that, the state came back and said, "Hey, if you do this, we'll give you we'll give you a diversion. The case will get dismissed." But in that case, the client has a friend or a family member that was an attorney, and the client said, "Hey, can you explain this, because you know this person's an attorney?" I said, "Of course, like let's have a meeting." And we had like an hour and a half meeting, and I walked them through all my thought process and what I saw, what the case law said, and they told their family member friend, "Hey, I agree with Foley. I wouldn't take this chance if I was you, because if you lose, you're gonna be incarcerated." And ultimately, the client didn't listen, and it worked out, right? The client said, "No, Foley, I want you to do it. I don't care. I thought I had a good shot at it. It was going to be tough, but I did it." And the reality is when I filed the motion, it put pressure on the other side and the alleged victims, and they came back and said, "Hey, if you do a diversion, I don't know, 15 community service hours or something, or you know whatever the diversion requirements were, we'll get rid of the case." So one time it totally didn't work out because the first person, right, that I told you about, they lost and they got convicted. The second person, I had already done 3/4 of the work. The last part was the trial on the DUI, and that worked out for him. And on the last case, I thought the safer route was to go with diversion. I mean, was not to file the motion, because the state attorney said, once I file the motion, if you don't win the motion, I'm going to retract my offer, and it's going to be an incarceration offer. And although I felt good about the motion that I'd put together, there's risk, right? When you have, you know, like probation on the table versus incarceration. I said, listen, it's your choice. And I did it. It wasn't really against what I said. It was, I leaned on the side of caution. Remember, my first goal, folks, is to keep my clients out of jail or prison, and to keep them from becoming convicted of their crime. So, I don't know. I just wanted to share some stories, and hope that sheds some light on, well, the last client didn't fire me. Actually, the last client, even though the friend and family member said, "Hey, I wouldn't file that motion, I think it's dangerous," they had enough confidence in me, and the reality is I was so bothered that the state said if I filed the motion, I really wanted to argue the motion, but I knew that if I lost the motion, it would harm my client. It's not what's best for me, it's what's best for my client. So when my client asked me, I said, "Man, I'd err on the side of caution, because if you go, I mean, I've already drafted the motion, but if you go and God forbid I lose, you know, you're going to be doing time." So, and a good amount of time. So anyway, I'm attorney Roger P. Foley, just sharing some stories and issues. Have a great day.